Good afternoon. This post-lunch session is little tough, I think. Everybody feeling very sleepy. So, rather taking a lesson, I learn from something from you, isn't it? You already have gone through a lot of IPR for, I think, yesterday also you have some session on IPR. So this is again this is our second lecture that you are listening today. So what actually the concept, how do you differentiate intellectual property with other existing property? Can anyone help me out in this, right? How you differentiate? Yes, please. Is it really intangible? So moment you documented it, the moment you fix it in some tangible form, then only you can call it a property. Otherwise, how can it become a property? Isn't it? Something intangible, something cannot be seen, touched, or thing. How can that then that could be pirated? That could be infringed. Could it be? So if it is not been stolen, then why should we thought about it any protection also? So no property is intangible in that sort. Though we say because the source is intangible, it actually comes under that intangibility form. So basically the property, intellectual property actually comes based on this intangible source. So as you defined it, that because intellectual property is an intangible property, we are protecting it. So ultimately the protection generates from the fact that when my idea, my thought, my hard work of thinking takes a form, some tangible form, that particular form can be protected. None other less. Nothing you can talk about without being fixed or being in a physical, something that has a physical existence rather. So today, since our area of talk is regarding innovation, so what is the basic difference between invention, innovation? How do you differentiate these two? Are they the same thing? Is it? What is the difference between invention and innovations? Yeah. Sometimes too. So innovation basically is something that we do for a betterment of the existing thing. That we say we have innovated the thing for a better use or better implementation, isn't it? Or to sometimes we try to suppose a product is invented, but now it cannot be marketed in that reasons. For that, some innovation need to be done. So this is how sometimes people say my innovation is, since I have done something innovated, it should be patented. It's not so always. So that differentiation has to be well known to you people, because you are now going through lot of patent, trademark, design, all these terms are coming from here and there, but you should know what are the differences and where to apply what. So as IPR, intellectual property right, is the creation of mind. This is the various laws that are protecting that right. And when we talk about these rights in that regard, we have to know which right should we go for, which protection we should seek for my item. So as a entrepreneur, as a new starter in this IP field, you should know that clearly. So in that regard, when your idea, any form of idea, as I said, is an intangible one. The moment, then how can I change into a tangible form? Only through this categorization. Whether it is an invention, whether it is just a look, or whether it's a quality or identification, identity mark of my, or some confidential fact which can change the company set or the planning of my work, or some artistic literary work. So accordingly, the rights are there. So I will slowly go through one, that is invention. When my work is in this technical field that you all belong to, being a student, many of you are inventing, we are doing a lot of research, so you may end up to a good invention. You may end up to develop a very good technology. Okay, so in that regard, you can obviously do a prior art search, get yourself acquainted that yes, my thing is a noble one and it is fulfilling all the criteria of patentability, and you can file a patent in that set. So in Patent Information Center, we give a prior art search for that, and there we actually help you to understand whether your invention is patentable or not. So by now you all know what are the criteria of patenting. You have to it has to be novel. It has to be it has to have an inventive step. Without an inventive step, whatever innovation you do in your set of work, it will not be called it will not be qualified as an invention. So for that, another most important fact is that it has to have an industrial application. That is also a very important criteria. All invention, all technological development or advancement will not be taken for granted if it is of no use, if you cannot develop, cannot be manufactured in industrially. So industrial application is a very important point. Next, the criteria is to judge the patentability of that any particular invention or any particular technology that you are working upon is the Section 3 of the Patent Act. I don't know how many people of anybody have gone through Section 3? Yes, yeah? Have you heard of Section 3 of Patent Act? Yes? Anybody? So it's very new to you. So let me go a little slow in that regard. I will come back to Section 3 and Section 4 later on. So as I said, in Patent Information Center, we give a service of prior art search that helps us to understand the novelty of that particular technology, where we go through various informations. As I said, novelty is judged based on existence of that technology before my work. So anything that exists before my work, my research, will be considered as my prior art. So it may be in India, it may be outside India. So it is not a territorial fact. It's a global or universal fact that nowhere it must exist. Then only I can say my work is novel. So when can I go for this search? Many people ask us a question, what is the right term for the search? There is no right term as such. You can search before you have the proper work being done, or after the work is complete, you can go for a search. So the aim of doing the thing is different. For the first case, you can, suppose you are thinking, as ma'am just mentioned, which way you should go, you don't know. In that case, we give you a direction after our search. We give you the report to let you know what are the prior art existing, what kind of work a landscape is going on, what area what are the gaps, wide gaps of the technology that you are interested in. So in that case, you can design your work accordingly. This is what you can do before going for further work. But if everything is done, then for filing a patent, because it is a matter of investment, another big investment, patent filing is not a small investment. So in that case, what you can do, you do a little homework about the thing that what are the prior arts are there, which can actually become a problem for me to claim my technology. So in that case, this prior arts, that searching report that we give, that helps you to identify that. Accordingly, you can modify your technology. So as I said, this prior arts acts as because when you submit your patents, patent office themselves also, they do a prior art search, and they accordingly they raise their objection accordingly. So they give prior art documents that they find, and they will ask you to come back that how is your thing is novel according to that particular document. So if you do this search before, you will be ready with your answer then. So the criteria, as I mentioned, accordingly we search for the patentability. To search that, we first, actually our team is there, expert team to search the these documents. We first go through the whole technology properly, and then we extract the main keywords, and obviously we combine the classification search also. I will talk about the classification later. So with that we form the exact query, and then we go for the searching. Next thing that we go is about, we also find out, we not only we take the exact keyword and do a query, we also find out synonyms out of it. It is because many documents may not use my terms. They may use their own terms. So one word may be of different synonyms. There may be different synonyms. So we have to take the synonyms also under consideration. So we combine keyword and classification search, and then we form our query according to the databases. So first I will show you some free databases that you can also go through. That is WIPO. WIPO has a patent database, that is patent scope, where you can go through you can undergo your own search. If your item is ready, you get the keyword for yourself, and accordingly you can search there. Apart from this WIPO, there is another site, that is European database, where it's going back. Yeah. In WIPO, there is another structure of system, that is classification, that I have just said, that classification. Here there is a very good pattern of systemical arrangement of the keywords, where if you take the keyword, and then you find the classification class, which class that particular keyword belongs to, and accordingly if you combine the keyword and the classification, then the searching becomes much more robust. It would be better, you can extract the exact documents that you are trying to find. So these are all present in the WIPO site itself. Anybody interested, you can explore them. So this is the main group of classification. Accordingly, they have subgroups and subclasses. Similarly, European country also have a database that is also equally free database. Anybody can use it, and a very good database. Here also you have smart and advanced and classification, where all types, whichever types you are comfortable in, you can type in. European state, WIPO, European state, and this United States. These three are wonderful database for a free search, and they gives both published documents, patent documents, and unpublished, means just granted one also accordingly. This is our Indian patent database. Here you can also go through for published database. Only actually all the databases that I'm showing you, they gives you only the published one. Those documents which are not published, you cannot see them. So that is the gap you have sometime while you are searching. And here you can very well see that there is a published area, and another box is there for the granted patent also. So these are the free databases that I've mentioned before. Now we will talk about, this is the two database that we use in the Patent Information Center of Departments of Science and Technology and Biotechnology, that is STN and Clarivat. This paid databases, for that you have to come to us. Otherwise, if your college buys it, you can also access that. So we not only do the patent database search, we also go with non-patent databases, but literature search is also very important. However, literature searches people already do this, but while we are also doing the patent search, we go through this non-patent databases also. So as I said, section 3, this section 3 of Patent Act is a very important section to judge the patentability. So any document, if they fall under this section, will not be able to patent it. So this is a section which actually excludes the thing from patenting. So it has various subsections. So these subsections are very important, and each subsection actually gives you an idea somehow that this, that like as we all know, many of you have a question that you are working in IT sector especially, when you have some software being produced, why can't we patent it? So this section 3 has a clause that computer programming cannot be patented. So that is the problem. That's why you cannot get a for that we have another form of protection, that is copyright. Any computer program or algorithm, mathematical derivations, this should be only protected through copyright in India especially. So that is the but you have a question, if it is embedded with a hardware and you can tangibly show that particular key, that this software is only been effectively work with a hardware components, and with that you can file a patent in that regard. So per se it is not patentable actually. So in as the section talks about the natural laws, it's very well known that any established natural law is the, if your technology is against that, then also it cannot be patented. If it is against any ethical reason, that in the morning somebody said, if you are building a gun, if you are designing a gun, in that case you will not be allowed. It is not that easy for you to get a patent out of it. So it is important, you have to justify your thing, accordingly you can be granted a patent. So scientific principle, natural living, non-living parts of any natural body is also not patented. You cannot take a part of a body out and then you say, this is my this I have taken out with my own technology and all, and that could be, that cannot be done. Process may be, the process of working out the thing is maybe the process you have extracted any particular thing, that could be patented. But mind it, again there is another clause, that is method of human or animal treatment, that is also not patented. So this is there is a very fine line on the thing, what can be patented, what cannot be patented. So each document we have to go through properly so that we can define out that this could be patented and this could not be, because we have to keep every point of this section 3 in our mind while we are going through this assessment. As in the morning only I have found, somebody said that we cannot patent any particular natural thing or any traditional knowledge, that like haldi but we have, as madam have shown you, that how many patents have been filed in this regard. How that could be possible then? Traditional knowledge is not patentable. Haldi names are most common traditional knowledge of our ears. Then how could it be possible? Formulation, composition. So they can be done in per se in that manner. So that's very important thing to understand. And how can I seek a patent out of? What am I doing? So for that we are there to help you in that regard. So I will elaborate in another very important case. Many of you by now must have known. Here you all are from biology background, biotechnology background. This is a very common, but in fact very thoughtful case, I would say, because at the very same time, this is a very important drug that could not be filed in India because of Section 3D. Because this multinational company has a tendency of taking patent of something they have already patented. After this term of 20 years, they try to increase that term by filing a new patent of a new form of that particular drug. That is to actually this section D actually brought that, because this section D tells you that no form of isomers or any crystalline forms of other same product could be patented until and unless there is some kind of efficacy being proven. In this case of nowadays, they could not prove the efficacy. That is the reason it has been rejected. So as I mentioned, section 4 also is there, very important section. No nuclear items can be patented. Radioactive material, if you are working with any radioactive material, that cannot be patented. So apart from that, I have mentioned already that there is another very important amendment that our Patent Act has, that is compulsory licensing. Have all you know what is compulsory licensing? Yes? Compulsory licensing is basically as I said, is a form of licensing, but it is actually used, it's a power of government. Suppose a person who is actually is the owner of the drug, and it is very life-saving drug, and the price of the drug is very high. In that case, he can put a compulsion on you to give this drug to somebody who can manufacture the drug in a lower price. So this is how the drug price can be controlled also. So this first compulsory license was granted to this NATCO from the this very one of these very important cancer drug, and because of that, the price of the drug, the NATCO is allowed to manufacture this drug as a generic medicine, and the price has been reduced to a large extent actually. So that's a very good example of and very good use of this compulsory licensing in India. So this is basically a very important way of controlling the various monopoly that the big multinational company used to have on their drugs and life-saving drugs. So this is another case for infringement, where I just mentioned any known substance, you cannot take a patent of a known substance. So that is here what Cipla has done. Cipla already has a patent on a generic drug and try to manufacture that, where Roche already have that particular patent on that substance. So they try to establish that their product is something else, but ultimately it has been seen that they are the two item is same. So that is the reason why Cipla was held infringing Roche's patent. So this is the cost of patent filing. So everybody, since you all are planning to be a good startup, a good entrepreneur, so you should know what is actually the cost of filing a patent. So this is the application, 1,600 is the minimum cost of filing a patent application, and later others, publication fees and others, they incurred into. So as already been mentioned, there is no international grant of patent. You can only go for an international filing. The two way of filing, one, you can directly go to each country and file a patent there. But what else you can do, and then that is a better way, that is you file under one single application under PCT, that is Patent Cooperative Treaty. So when you file one application, why should I not opt for the Paris Convention one? Paris Convention, that I said, that you have to go to each and every country within 12 months of the first filing of your application in your own country. So from that, you only get a 12-month time to go to all the countries one by one. But if you file through PCT, then you can very well see that there is a time lag of 30 months. So from the first filing in your home country, from that day, you get a time lag of 30, or in some country, 31 months is also allowed. It varies from country to country. So I'll not go in detail of this PCT. If anybody interested, you can go through. So PCT, obviously, since it's an international filing, amount is also varies. So 3 kind of fees that you have to pay. That is international filing fees, search fees, and this transmittal fees. So next item in IPR, intellectual property right, is the design. So somebody said, I think Dr. Moha Chaudhary have spoken about the fact that design registration is a very important registration, and obviously it is not patent in India. It is actually USA has a practice of calling design as a design patent, but in India we say design registration. This practice has a very good I would say small business house. Suppose somebody who don't have that very good idea, they don't have a patent, you can go for this design registration, because design registration, the cost of protection is also lesser, and the hazard and the complexity is quite less than that of that in case of patent. So design registration could be a good option for you for the small business houses. So what is basically this design registration? Design actually about the aesthetic look, just the appearance, nothing to do with how the product is being built, nothing to do with how the product is being manufactured. It's important is the look, how it looks, how appealing it to my eye. That is very important for the design registration. So the aesthetic view is important for design, because that actually helps my product, design that helps my product to be approachable for towards the customer. Means my customers get attracted to my product. That is 2 or 3 dimensional or in any form can be registered. Manufacturing through any means of industrial is allowed in design registration. It has to solely be judged through by eyes, nothing else. So that's very important. And the method of is not important, but what is important is the article. When you are registering any design, you have to keep in mind which article you are trying to apply it. So that is very important for the design. So you have to mention that in your application. So obviously the terms is also quite less than the patent. In case of design, we have only 10 years, and you can extend it up to 5 years. And another most important thing is not all design are registrable, like certificate designs, the stamp design, trademark. They have separate regime. As trademark and copyrights, these are separate regimes actually. You have to understand that these two are not same, because cartoons or those diagrams, those are protected through copyright. So this is a case of such design. This is a very interesting case in 2020, when this Gopal Glass has a design. They try to register their design for diamond-shaped glass sheet. Okay, and they found that Bharat Glass Tube is already involved in business, and they are marketing this form of design with the German company. And this German company claimed that they have a design, this kind of diamond-shaped design for a glass for their business. And what actually becomes the problem, though the design is the same, but the output of the design, the glass, when the Gopal Glass have applied the effect of the design on their article, and the German company and the Bharat Glass, they cannot prove to be the same, the effect of the design on the article. So that is very important. That's why I mentioned the design with the article is very important. So since the effect, the two effects are different, the Gopal Glass, even having the same design, they were allowed to register. They got the design registration. So therefore the novelty and everything is just judged only through by eye. So the effect, how much it is appealing to the eye, that is important in case of design registration. So these are the sites where you can go for a design registration search. If you have a design, you can search other existing prior designs from these sites. This is the cost. I said it's very less. All other IPRs, this cost very less actually. So only 1,000 rupees in Indian territory, you have to file an application of design. Obviously, the class for a particular class. Then the thing I'll come to is, as you all know, idea when some logo that you create, company logo or some product that you are launching in the market, it's carry a logo with it, isn't it? So that mark which creates a recognition between you and your customer, that actually talks about can be protected through trademark, and in case another form of is geographical indications. This well-known trademarks, we all are acquainted with these trademarks. So how this trademark is so important? How can anybody can tell me what actually the trademark is basically? Why this is so important? Why it is a property? Why it is a property? Yes? It's an identity of a particular company. Fine, but I want to know it more clearly. How, suppose I know that this product is yours and I know you buy that, but how that matters? Even if I have a recognition, how does that matter? How is actually establish the connection? Yes? Goodwill. This is a very important thing. Goodwill. I have used your product. I know that this is good. So that gets registered in my brain. That this logo, the person who is using this logo is the owner of this product. This product is good. I know this. Even if there are thousands of products alike, I will take up that because that what I have registered in my mind. The goodwill. So copyright, the trademark is basically talks about some connection with the customer and the consumer of that link is that they build after uses of that product. So this is what actually trademarks helps us to understand that whenever there is any kind of problem with my mark, I know that this company is the best. I will use this product of this company. So the trademark is my visiting card, and it becomes the brand name at that time. So in case of the case that I am showing here one YouTuber has disregarded this parachute oil in his speech in the YouTube. So the parachute company owner, Morocco, he filed a suit against the person, and he said that my goodwill has been taken into stake because of this person, and court has forced this person to remove the video from the website. So this is how you can protect your brand actually. So that is the reason why, because the trademark, as I said, you can use it without registering also. It is not mandatory always that you have to file a trademark registration, get it granted, and then use it. Because many trademarks are there that have been used like that, and later on they've been registered. So registering your trademark is not, but in case of protecting it from any kind of litigation of like this, registration is required. So that is the reason why we need to register them. So trademark can be of various form. It could be a product, it could be a service. So accordingly, the mark is appointed. So most important thing that when you are building, suppose you have a idea and you have a company, and now you are thinking to have a trademark. So in that case, you have to know what should be the quality of what are the basic requirement of the trademark. So two thing is very important. It has to be distinctive and it should not be deceptive. So what do I mean by distinctive? Anybody? You know what is meant by distinctiveness? Different from the others, but how? Obviously, because every IPR is about novelty, new, originality. Okay, I will take a protection because it is original, different from others. But here I am talking about distinctiveness is something different. It is no, actually, many of you use iPhone, isn't it? Right? Using iPhone? Many people use it. No, it's okay. Fine, nobody wants to disclose it, it's okay. But many of you use it. Have you seen this half-eaten apple? It is a trademark, do you know that? Yes? So what does iPhone has to do with this apple? Are they growing apple? Are they growing apple? Then why are they using the logo with half-eaten go? Yeah? No. Now that is not the reason. This is distinctive. This is called distinctiveness. Actually, it is not associated with, it is not easy to think of it. It is not so obvious. You cannot actually, there is no connection with it. It's abstract. Completely abstract. If a apple growing farm take a logo of an apple and put it in front of you, you won't remember in that way. Rather you remember this. We try to remember the abstract thing first. This is actually the scientific, because you always have a tendency. Suppose I'm manufacturing some furniture goods. I try to make a logo of a chair. That logo won't be strong. This iPhone using a logo of half-eaten apple is much more stronger logo. So this is actually what, when you design your logo, it has to be an abstract one, not at all easily understandable. Okay, fine, Apple phone, it's a sign of a phone. Then nobody would have taken it in that. The logo wouldn't be so distinct. And what about the deceptiveness? I said you should not be deceptive. That's very easy. Suppose you are having a leather product, obviously manufactured artificial logo. You are telling real leather. People will take it, this is a genuine leather, but it is not so. So that is what it should not be descriptive also. Because you are trying to describe and trying to put something wrong in the mind of your customers. So these two characters you have to remember when you are designing your logo. Then there are other form of trademark, the certification mark. Certification mark, as the mark talks about, it's a set of standard. When that standard is been, whenever any particular product or something follow that quality, that amount standard, maintain that standard, they are allowed to use these marks. Similarly, there is another form of mark, that is collective marks. These are group of company that they can use this particular mark. So we can recognize from this company belong to that group. So when my logo is registered, it is depicted through R, and when it is not registered, it is just mentioned TM. That's fine. Similarly, trademark also have a first tenure of 10 years. 10 years after filing, you get the protection, but after 10 years, you have to pay the fees for your renewal. And you can renew it as long as you want. So this is also an example of another case, very important, that Yahoo we know is a big brand name, but some company started using Yahoo in their portal, and that was this litigation came in front, and they were not allowed to do so, because this is already a well-known thing. Because the people who are using internet, they may get they get confused that this may be the Yahoo same company. So that it is not so. So same problem with ISKCON. ISKCON has this logo, and government company, they try to use this ISKCON name in their company head, and that also become a problem, and this is a case of infringement again of trademark. Trademark search also can be done. If you have new trademark been designed for yourself, you can go for a search for it and find that whether it is okay, then go for a filing an application. In Indian government, we have trademark search facility, and also WIPO also gives a portal where all international trademark being filed can be searched. This is the fees of filing a trademark application for an individual, startup, or small enterprise. Obviously, one application for one class. Next, another form, everything is same in case of geographical indication. As you all by now, you have know that geographical indication, we talk a lot about this Rasgulla, Bangla Rasgulla and all. So it's not patent, it is completely a form of trademark, that is geographical indication, but it is owned by a community, not by an individual person. No one person is the owner of this, like trademark. So this is the difference between the GI and trademark. The protection, tenure, and everything is almost same as that of the trademark. 10 years first, then after that, it has to be renewed, and we can keep it renewed as long as one want it. So the next IP that we'll talk about, if you try to keep something confidential, if you try to, you don't want to disclose your IP, in that case, you go for an internal agreement, like Coca-Cola with their recipe, what they have done. Many other big multinational companies, they follow this also. Because always it is not that go for filing a patent and disclose everything. Because when you are filing a patent, you are actually disclosing everything. So nothing remain hidden at that time. So that is the most important thing. If you want to go for, then you have to maintain that as a trade secret. So trade secret is done with the help of some agreement on non-disclosure contracts. So that is also a good practice for the various companies. So next is a way of protecting your idea in form of any artistic work. You write a poem, you write any, suppose any concept, theoretical concept that you have thought of, but you don't know how to apply it in a such. So at that time, how will you, but it is very valuable one. Many theoretical research we do. So you can protect it through copyright. So there where copyright comes into, and I feel it is most complex area of IPR, because copyright is not a single right. Copyright actually talks about lot of rights. It's just not the author right, it has other various related rights. So copyright is basically a bundle of rights. So copyright, as per Indian Copyright Act, again the thing, it is actually though it's a negative right, nobody is allowed to use your work without your prior permission. Nobody has a right to copy it. Nobody has a right to sell or do anything with that particular thing. So for that, this copyright is also an automatic right as per Bern's convention. But what is the most important is that it has the protection. The term of protection is very interesting. The authors get the protection for the whole life, plus 50 to 70 years. There's a range. You must be surprising why there is a range, because some country allow is for 50 years, some 60 years, some 70 years. In India, it is 60 years. Like the work of the Rabindranath Tagore, now it is no more under copyright protection, because that 60 years also is over. So there is another new form of doing it is now been translated. Being translated, it's become a new form of copyright, and then the whole life of the author plus 60 years can be given as a protection. So as I said, there is various form of this bundle of rights. We call it economic right because from it we earn. So it could be any form of translation, any distribution, public performance, public communication. So it's a whole lot of bundle. Some are mentioned, I would say. It's something that has been mentioned. There are more rights are associated with this copyright, related copyright. So another most important thing with this economic rights that we talk about, copyright also has the moral right, and this is not transferable. Even there is an assignment, I have given all my rights to somebody else, because when sometimes it happens when a writer is writing a story, he has to sign an assignment, okay, with the producer of a film to do the film. So at that time he may give his copyright to the film, but this moral right remains with him. This cannot be transferred to anybody. So that there's a very important and very interesting case that is, and very old one also, Amarnath Sehgal's case with the government of India. He has, it's a time of when Pandit Jawaharlal Nehru was our prime minister. He built a mural for government of India, Bigyan Bhavan. And there, that mural was fine there, but later on it happens for the renovation, the mural has to be removed, and it's not been taken care properly. So at that time, the Amarnath filed a sue against the government of India, and the government has to compensate him for that. And the mural also, since it was removed from the place of display, they have returned the statue to him after that. So this is what we have for the copyright at most. If you have any question, we can go about with it. So before I end with the copyright, there's another interesting thing. Today I have shown you a lot of things. So I have collected it from various sources. So do I have taken the permission of everybody? No, I haven't. But then am I not infringing? Right? Am I infringing? I am using others' work to make you understand what IPR is or what all IP laws are. So no, in my case, because I am trying to teach you something, this is called fair use. Because I am not actually doing any business with it. I am not earning anything out of it. So this is not infringement. So copyright has this exceptionalities where you can have a fair use. But if I do this copying and more than 50 copies, then again my work is becoming a case of infringement. And another thing is that I just give you a short. When you've been employed by somebody to perform a job, the copyright belong to your person who is paying you to do work. Not even if you are doing it by your own. Even the thing it belongs to your, but you are assigned to do that work. So the copyright actually belongs to the employer who is asking you to do, who is actually employed you to perform the work. Okay? Obviously, in absence of any agreement, in any contract. So this is what we have for copyright till now. So this is again another case of infringement in case of copyrights. Somebody has broadcasted someone's, so that is also not right. So this is the cost of filing copyright. Cost of filing a copyright application is very minimum, 500 rupees. You have any document, many a time, what else you can do? You post your, suppose, doing any kind of work, documentation is very important. And many a time how it happens, two people working in the lab, one is very smart, go and file an application in his name, another person was ignorant of all this process, was totally unknown, and he has to suffer. So what you should do, you should always maintain a daily journal. That is what in the morning also people said that maintaining journal is very important. Maintaining a proper diary, regular diary. So what are you working on a regular basis, that should be maintained, and that become a copyright thing also. So in case of any litigation, in case of any problem, you need to oppose something or you have to prove your work, that journal becomes a very good evidence. So thank you for your patience after the lunch. Any question? Yeah, any question? There are many litigations going on regarding that. Definitely there is, but definitely they've been settled properly. Okay, they've been taken care of, because this industry is very active with all kind of litigation.
Thank you, ma'am, for giving us a very informative speech. And now I would like to request Dr. Chatterjee the declare of the results of exhibition and prize distribution. And I also request to Dr. Devashish Dotto and Miss Shongita Sengupta to come on the dais, please. And ma'am also. And I would like to request Dr. Chatterjee to felicitate Miss Paromita Saha. Thank you. And also Miss Shongita Sengupta. Thank you. And now I would like to request Dr. Chatterjee to declare the results.
Good afternoon, everyone. I know it has been a marathon journey of more than 6 to 8 speakers, in-depth discussing about various aspects of IPR. But I feel that being students of science and technology, especially biotechnology, it is very important for you. This prize distribution ceremony is not the end of the program, but because we'll have another short talk after the prize distribution. But because of the cruelty of time, we are having the prize distribution a bit early. Now, all the posters has been judged by several resource person, mostly external resource person, and it has been a very difficult job, as they have intimated to me. So though I take the privilege of announcing the results, but it has been a roller coaster ride for us to cumulatively get the results. However, the third prize for poster presentation goes to poster number 5, patent in biotechnology. Can I have the team? I request Ms. Paromita Saha to hand over the prize to the team. The team can please come up. Can we have a very big round of applause for this team? The second prize goes to team number 7. Anyone who remembers who is team number 7? Team number 7 no one remembers. So shall I keep the prize with me? It is Koenica and team. And their topic was geographical indication. I would request Ms. Shongita Sengupta madam to please hand over the prize. If everyone can join. Yeah. Any guesses for the first prize? Any guesses? The first prize was definitely unconventional. Any idea? Any wild guesses? It was patent a double-edged knife by Somriddho Mukherjee and team. Can we have them on the stage? Can I request Dr. Debashish Dotto to hand over the prize? Wonderful job by all the teams. Thank you very much. Now there was even difficult task because we thought of giving the best innovator award. Though we got some entries as entrepreneurs, first let me mention which all innovators and entrepreneurs were highly appraised by the jury members. Among the entrepreneurs, Krishnolekha and Andragogi was highly appraised. Among the innovators, Infinity, Biopatch and Biotechnology Club was highly appraised. But the best innovation goes to Proteinex, Debjit Safui from Proteinex. So can we have a very big round of applause for Debjit? And I request all the jury members to please join hands in awarding Debjit the Best Innovation Award for this year. Can we have a big round of applause? I would once again request all the winners to please come to the stage once for a group photograph. All the winners. as I said, this is not the last. Now I request Ms. Shongita Sengupta Madam to deliver the last talk for the 2-day program celebrating International IP Day, as well as the inauguration of Patent Cell, IPR Cell, supported by DSTBT, Government of West Bengal.
Good afternoon. I can see still students are sitting for my lecture, so I think they are very much interested in this field. That's why they are still sitting even after the prize distribution and everything is over. So I will keep my lecture short. Very few tips, the essential tips which will come in handy in your journey of invention, and if you wish to be an entrepreneur. Those are the things I will be discussing. Now I will limit my talk to patentability. Now you guys are, you have heard about many types of IPR. I will be limited to patents. Patents are given for inventions, something which is a product of mine, which has a technical advance, that is given a patent. Now you might be aware that patent is a territorial right. What does that mean? Means if you apply for patent in India, you will get the right for in the territory of India only. Your patent rights, the rights which comes with your patent, will be limited to India only. Similarly, if you go for US, if you want your implements your right in US, you have to go to US and apply to their government for patent, their patent office. Same for EU. So based on the country, there are differences in the law. If you are aware, now these things which vary, it comes under section 3 in India, which is implemented only in India, and there are variations. But there are 3 cardinal criteria which is universal in almost all countries, which is the criteria for judgment whether an invention will be eligible for patent or not. We will be knowing in this lecture what are those 3 criteria. Now the 3 criteria are novelty, inventive step, and industrial application. Now we will be knowing what are these 3 criteria are and how it's implemented, how is defined. Now what is novelty? When is an invention considered novel? When an invention is considered new or novel, if it has not been disclosed in anywhere in the world or practiced anywhere in India or world. Now, few minutes back, I told that when you get a patent, you get for a particular territory. Like you are applying for India, you are getting patent rights for India only. But the novelty of your invention is judged worldwide. So if an invention is not used or published anywhere in the world, then only it is considered novel. Now there is a term called prior art. What is prior art? Prior art is the art which nullifies or invalidates your novelty. Something, some information that is quite similar to your invention, which brings your invention into public domain and hence nullify its novelty. Now, what are those informations that can be considered as prior art? It can be a prior publication. You guys may be publishing research paper. Even if you have published a research paper of your invention before going for patent filing, that research paper, your research paper, will be considered as prior art and will nullify the novelty of the invention. Then there is oral communication. You are presenting in some seminar. If you have presented your invention in some seminar before filing a patent, then it will also nullify your novelty. You have demonstrated your model. Many of the researchers have demonstrated their models in here itself, and we have judged it. But I must appreciate a person, I don't recall his name. He was working on some dye, tagging DNA and RNA, and he told me the invention, which was enough to judge his invention. But he didn't disclose the nitty-gritty. And that is the technique, what you should apply when you are going for an exhibition or presentation in some learned society. Don't give the details, right? If you have not patented it, don't give the details. And then public user trial. If you are testing your device or your invention in some trial and it comes into the public domain, nowadays newspapers and media person comes to cover events and it becomes viral. So ensure that if you are going for a trial or something, then first file patent, then do all these activities. Okay, so here is a interesting case which happened with Apple company. You might be aware that Apple is a very IP savvy company. Wherever, every now and then there is a news. Those who follow the Apple trajectory and their products, you will know that they are fighting with Samsung or Hawaii, some other company they are fighting with regarding their rights about their inventions. So even once Apple did a mistake, what happened is, every one of you must be having a feature in the phone. If you scroll down the screen of the phone while searching for an information, if the information ends, the screen bounces back. Now that is called rubber band effect, and that is an Apple invention. So what happened is, what Apple generally does before launching a product, what they do is they come for an event. The CEO comes and he tells that we will be launching iPhone X or iPhone Y, and these are the features which this new phone will be having. So in a similar event, the CEO disclosed about this rubber band effect. But unfortunately, till then, their IP team has not filed patent for that feature. And when they went for patent application in US Patent Office, the Patent Office said already your CEO has disclosed, so the information is in public domain and it cannot be patented. So we should learn from this. Even giants can make mistake. So we only suggest always first go for filing, go for patent filing. Even if you, I was talking to some inventor here in the exhibition, and he was telling, madam, I think it's some hydrogel for curing they were doing hydrogel formulation for this burn victims and all. And he said that I am under a process, we have not completed our research. So maybe after we complete the research, we will go for patenting. Now, it can be leaked. Even in today's exhibition, it could have been leaked. So what we suggest, if you have some idea or you have progressed, you have some experimental data and a rough invention, and you are not sure you want to fine-tune it, it's fine. You go for a provisional patent application. What is provisional patent application? You have to give an abstract of your invention and you have to apply for patent. And you get a 12 months grace period to file for complete application. And in those 12 months, you can fine-tune your invention and go for complete filing. Now there are certain graces, certain things in our patent laws, certain situations where even if the information or of an invention comes in public domain, it is not considered to be nullified and government gives a grace period. Now let us know what are those situations. Suppose somebody took your invention and published it without your consent, and you are able to prove it to the court of law that the invention which came into public domain was without your consent, acquired from you fraudulently, then it is government gives you a grace period of 12 months for filing the patent application. Again, you have to prove that as soon as you knew about this coming of your invention into public domain, you went for filing. Suppose if your opponent is able to prove that you had the knowledge and you thought, you procrastinated, okay, maybe tomorrow, day after tomorrow, if you deliberately, knowingly delayed, then this grace will not be applied to you. Now, many of us are doing research which is government funded, and we have to give reports every year about your work in progress. If any information of your invention is leaked by that means, then also this grace period is given, and it is considered that your invention as if it has not come into public domain. Again, if you are presenting in some seminar or exhibition where that exhibition is coming under this provision and government has notified it in any gazetteer, then also you get this 12 months grace period. But we should not go for this exception. What we lawyers suggest, first file and then go do anything, because these are subjected to interpretation. You have to go to court of law, you have to prove, you have to fight, and we should not be wasting our time like that. The patent application charges for a normal person is 1600. So that much I think we can bear. First file the patent application and then go for anything you wish. Now here is a case study. Now what is novelty? I am limiting my case studies to biological sciences because many of you are here. I think maximum crowd is of biological sciences. So how a invention dilutes your novelty. So what constitutes a prior art in biological sciences? Here is a case study. Suppose there is a library containing many sequences, and it has been disclosed in some research paper or in an application. It has already been there in public domain, and you have worked with a polypeptide sequence, polynucleotide sequence within that library. Maybe in the full library, the function of that polynucleotide was not known. You did something innovative with that polynucleotide, but it will be considered already disclosed in public domain since the library is already disclosed. Again, there is a scope and invention. Suppose you have formulated a composition or method of production where you are using 5% to 20% of HCl, the range you are using, and somebody already used a 10% HCl doing the same process. Then also you cannot claim the entire range because there is already an invention which is falling in the range. Okay. The next, it is a very important criteria for judging patentability of an invention. It is called inventive step. Now what is inventive step? Inventive step is defined in Indian patent law as any technical advances to existing knowledge or economic significance or both, such that it is non-obvious to person skilled in the art. Now who is this person skilled in the art? The person skilled in the art is somebody who is working in that field of invention, your peers, who has the knowledge of that field. Like I may be expert in biology, but I won't be a person skilled in the art in IC or integrated surface inventions. So skilled in the art person is the person who is particularly working in that field and who can easily guess what you have come across. Now here is a case study. The claim already, the claim of the new invention was an improved process of production of GOS using Brucella singularis and Saccharomyces. And the subsequent steps it is disclosed here, you can see. And what the prior art disclosed? Prior art disclosed that B singularis was used to get GOS from lactose. And there is another prior art which disclosed that Saccharomyces are used to get GOS. Now a person skilled in the art will be tempted to combine these two to get a higher yield. So this, in this case, this invention is not patentable. The claim which they have in black I have written, that is not patentable because from the prior art, any person working in this field can easily guess this invention. Now here are two recombinant DNA sequences. Now what the new invention says is it has a sequence ID code X encoding human interferon alpha 2 polypeptide. What existing invention is there is a sequence number X1 encoding human interferon alpha polypeptide. But here the alpha 1 polypeptide and alpha 2 polypeptide are similar in structure. But what the new invention is doing is the alpha 2 has 30 times more potency in antiviral activity than prior art. Now, although both are in similar structure, but this 30 times increase in the activity, that is the innovation. If generally what we will guess, that if they have similar structure, they might be having similar functions. But in the new invention, there is 30 times increase in the activity. Now, this is a innovation. This person who is working in the field won't have guessed. This is the addition of the inventor. So, in this case, the invention will be patentable. Now, here is another case. The new invention claims the DNA sequence encoding mature human IL-3 protein having a proline residue at position 8. And the prior art, what is claimed is a mature human IL-3 protein having a serine residue at position 8. Now, the person in this field will know that IL-3 is a type of polypeptide where having similar structures, and one single mutation won't have much effect in their function until and unless it is a point mutation where it is terminating the chain. So, for a person skilled in the art, this will be easily understandable or guessable. So, this invention will not be patentable. Now, thank you. And if you have any query, you can shoot or you can mail us at our email ID.
Thank you, ma'am, for giving us a very informative speech. And now I would like to come on the stage Dr. Saptoshi Chatterjee for the photo.
Though the phrase says vote of thanks, but saying thanks would not be enough, because though I can see the gradual decrease in the number of students, but I was discussing with one of my colleagues that the role of a teacher can be very well explained by a story called a starfish story. I'll just end with this story. It says there was a little kid, and you know, when there is a high tide, the starfish come to the shore and get stuck. They cannot return to the sea and they die. So a child was picking up one starfish and throwing it in the sea to save the life. An old person came and asked, there are millions of starfish. How many life can you save? The small kid replied, sir, I might not have the capacity to impact the life of the millions, but look, this is a starfish. It is going to die, and when I throw it, now it has lived. Similar role is of a teacher who delivers irrespective of thinking what would be its impact on the recipient, because even if one patent comes out of it, even if one person gets ignited towards IPR, that's the success of the program. I take the privilege of thanking the entire university fraternity, including the management, Honorable Chancellor Sir, Professor Samit Ray, Vice Chancellor Sir, Professor Dr. Naveen Das, Pro Vice Chancellor Dr. Dipankar Bhattacharya, Dr. Amolesh Mukhopadhyay, the Dean, School of Life Science and Biotechnology, Professor Dr. Rudra Prasad Shaha, all my faculty colleagues of School of Life Science and Biotechnology, and others who have supported us in organizing this event. This event has been a great conglomeration of resource person. Right from yesterday, we have listened to Professor Pinaki Ghosh, IPR Chair Professor, NUJS, West Bengal National University of Jurisdictional Science. We have witnessed the lecture from Dr. Shankhadeep Pal, Examiner of Patents and Trademark, IPO Office, Kolkata. We had Dr. Rahul Kapoor, Turn IP Innovations. Today we are fortunate to have Dr. Mohua Hom Chaudhuri, Dr. Paramita, and Shangita Madam also. We had the privilege of looking at the aesthetics of two beautiful GI from West Bengal. They are Dokra and Madur. And we have also been entrusted on popularizing two GI from West Bengal that I have said in the welcome note in the start of the day, that is Bangla Rasgulla and Govindabhog Chal. So going forward, with the help of everyone, all the resource person, as well as my faculty and student colleagues, we hope that we will be able to keep up the spirit. We would be able to file more and more number of IPR, bringing laurel not only to our university, but to our state and country. We have elevated from 81st position in Global Innovation Index to 41 in the last 3 years. But that's halfway. We have to be among the top 10, as we are almost in the top in terms of population. So with a positive note that we can do it, and again respecting the women innovators and women entrepreneurs, we had more number of women scientists and speakers in both the days. So I thank everyone, without whose cooperation we could not have achieved this success in terms of workshop. And finally, I would again like to thank Patent Information Center, DSTBT, Government of West Bengal for supporting us and establishing the IPR cell at Adamas University. With this, I thank you all. Thank you. Have a nice time.